Good afternoon, everybody, and thank you for joining us today for the second installment of the USPTO quarterly webinar series. We're coming to you live today from the USPTO with a virtual town hall meeting. I'm Peter Pappas, and I'll be moderating our webcast today. These virtual town hall meetings give the public a chance to speak with senior USPTO leaders and have a candid conversation about what is going on at the office. This is a particularly fitting time to be holding this webinar because we are very busy here at the USPTO implementing the Leahy-Smith America's Invents Act in several important ways. We've submitted 2 reports to Congress recently, one on small businesses and one on prior user rights, and we've recently held a public hearing on genetic testing. We also just held an important hearing on our newly proposed fee structure, and we'll be holding one more hearing on our fee structure in the next couple of weeks. As many of you know, we've already implemented 7 provisions of the AIA, including an important acceleration program that allows us to complete the processing of your patent application within 12 months for a fee, and we've completed drafting proposed rules for 9 more provisions. And in an effort to more clearly explain and answer all of your questions about these changes, we held an AIA initial roadshow at the USPTO on last Friday, and we're about to engage on a nationwide series of roadshows in 7 different cities where we can explain the law's proposed rules. With all of these efforts underway, it certainly is an exciting time for all of us at the PTO. And we are looking forward to this ongoing conversation with you today. Joining us today, to my immediate left, are the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, David Kappos. To his left, Deputy Undersecretary of Commerce for Intellectual Property and Deputy Director of the USPTO, Terry Wray. To Terry's left, Commissioner for Patents, Peggy Focarino. To Peggy's left, Chief Administrative Patent Judge for the Board of Appeals, James Smith, and to my right, USPTO General Counsel, Bernie Knight. So we have been receiving your questions all day today and last week, and we will continue to be receiving questions live via the web. So I'm going to now turn to the first question, which is directed to Commissioner for Patents, Peggy Focarino. Peggy, the first question relates to the agency's proposed fee structure. From the initial application to the issuance of a patent, is the cost of a patent increasing, and by how much? And what is the impact of these increases on small entities? And how does the USPTO, how do the agency's fees compare to the overall cost for an applicant of prosecuting a patent?
Okay. Well, the mandatory patent fees through issue, which includes the filing fee, the search and examination fee, publication fee, and issue fee, currently totals $3,290. That fee would be reduced to $2,800 under the proposed fee schedule. And for small entities, the mandatory patent fees through issue currently total $1,645, which would be reduced under the new fee schedule to $1,400 for small entity and $700 for micro entity. So this really supports our strategy to encourage innovation and reduce the cost to applicants at a stage when the value of the innovation is really uncertain.
Thanks, Peggy. A follow-up question. I understand that the USPTO needs to charge more to recover the costs of the services it provides to its users. But does this mean that a patent will be examined faster? And what other improvements can independent inventors look to, or what can we expect as a result of the increase in fees?
Well, the increased fees or revenue will allow us as an agency to have the funding we need to hire additional examiners and to continue to improve our IT systems. That translates to reduced pendency while maintaining or improving our quality. And all patent applicants, not just independent inventors, should benefit from this. However, with respect to the independent inventor community, decreased examination time would allow you to bring to market sooner your IP assets. So I think there's a unique benefit there to the independent inventor community that will be realized by our decreased pendency.
Thanks, Peggy. The next question just come in relates to satellite offices. We know that the USPTO intends to open a satellite office this summer in Detroit, but we'd like to know whether the USPTO satellite offices will be closed off to the public, or will they have public search rooms like West Computer Search Terminals, large and small meeting rooms for public and intellectual property bar association meetings, display and museum areas, etc. And that question will be for Director Kapos.
Well, thanks, Peter. Thanks for the question, and thanks everyone for joining this afternoon. So relative to satellite offices, we're going to try varying models at these offices, but one thing we're going to try to do across the board is to ensure that our user community has maximum access to the agency. So we do have in mind for the Detroit office, the one that, as Peter mentioned, that we're looking at opening this summer, to have public search capability in it to enable members of the public to come in and search similar to what they can do in our public search rooms here at our Alexandria campus, and also to have meeting room space, particularly for applicants or even appellants to come in, conduct interviews, conduct meetings with our team, and to have the ability to conduct some larger meetings in our facilities also. Now, this is all, however, within the parameters of initially, at least in Detroit, a rather small footprint. So we'll be growing over time, we'll be learning over time, but we do have the vision of these satellite offices, starting with Detroit, providing a lot of opportunity for the public to come in and directly interface for the agency. It's one of the key reasons why you would have satellite offices in the first place, is to get the PTO out into communities across the country.
Thanks, Dave. The next question relates to invalidity challenges, and the question is, where invalidity challenges in the district courts may take several years, how does the board plan to dispose of a trial proceeding within 1 year? And I think we'll turn that over to Deputy Director Ray.
Thank you so much, Peter. What we plan on doing with the proposed America Invents Act board rules is to streamline and actually converge the issues so that everything will be handled within 12 months. The only claims that will be considered will be those that meet the threshold requirements. We plan on keeping the parties to a very close set of defined due dates so everybody knows what's expected of everybody else. We want to balance the interests of the patent owner and the petitioner so that we actually arrive at that 12-month time period where everybody has had an opportunity to present their case. Now, in the unusual circumstance where 12 months is not sufficient, we may take an extra 2 weeks, an extra 2 months, or whatever may be necessary. But we will make every attempt to adhere to the 12 months, Peter.
Great, thank you, Terry. This next question is for James Smith. James, aside from hiring more judges, and we've certainly heard a lot about the agency's efforts to hire more judges, what is the office doing to address the board's backlog of ex parte appeals, and how do you feel about your prospects for good progress on that?
Well, first, even though many people in the patent community will have heard about our judge hiring efforts, I wouldn't want to pass on the opportunity to speak about it just for a second more, even before speaking about the other things that are being done. The judge hiring effort, or put another way, the effort the agency is taking to present names to the Secretary of Commerce through the Undersecretary for appointment to the board, have been very robust and aggressive and productive. We are amazed and pleased at the caliber of the candidates who have stepped forward and the pace at which they are being appointed to the board. Currently, about 25 judges have been fully through the appointment process, and some number of those have started at the board already. We have another dozen names that we believe the Secretary will approve possibly before the end of the month. Altogether, our efforts are likely to bring us a number of judges appointed to the board in the range of 50 sometime by the end of March. So we're excited, and we're excited because that is the main thing we can do really to address the backlog, have the human resources and the very specialized human resource to decide the cases. In addition, we're doing 2 or 3 or 4 significant things, including, for example, we are very focused at the board in making the decisions as efficiently as possible and making sure the written pronouncements of the decisions are also as lean as they possibly can be, while not being any less robust than they need to be. In particular, we have a per curiam decision initiative underway this year. We're on pace already to have probably 10 times as many decisions decided by per curiam panels this year than in 2010, for example, the year in which, prior to this year, we had the highest number of decisions which could be seen as falling within that category. The lean effort to announce the decisions and spend no more time on cases than is necessary is a big initiative for us. We also have incentives now in place to reward extraordinary output by judges, and already that's meeting with some success. To go to the second part of your question, are we seeing progress with the backlog? The answer is a very definite yes. The output from the judges who are already at the board is higher than it has been. It's also more level than it's been. We expect in the first calendar quarter of 2012 actually to see from the board 2,500 decisions. That will be an all-time high for any quarter in the board's history. We hope to level off at least that number, have it be our floor, and then go higher. We may in fact see as many as 10,000 decisions from the board this year, just from the judges who are already here, and then add to that incrementally the production of the newest judges. So we're excited about all we're doing to reduce the backlog.
Excellent. Thank you, James. Shifting gears now to our next topic, which is a copyright question. The question is that piracy is on the rise in America, and what is the USPTO doing to help stop piracy of content? And I think that question will be for our General Counsel, Bernie Knight.
Great question, Peter. We're actually addressing piracy on a number of fronts here at the PTO, and just off the top of my head, I can think of 4 major initiatives. Probably the first would be our international agreements. We work with the U.S. Trade Representative on those international agreements and make certain that the agreements include provisions to protect U.S. IP interests. Second, we engage in advocacy in the United States and around the world for efficient and effective enforcement mechanisms to protect U.S. IP interests. Third, people are probably aware that here at the PTO we have our GIPA Academy, our Global Intellectual Property Academy, where we provide training to people within the United States or around the world on issues related to IP enforcement to prevent piracy. And then fourth, I think a very important initiative that we have is our IP attaché program. And we have attachés in countries such as Brazil, China, and India. And the attachés are on the ground in those countries working with the foreign governments to make certain that their laws and regulations, as they're enacted, have provisions to protect intellectual property, and especially U.S. interests in those countries. So thanks for the question.
Sure. This question relates to IT, and I think we'll direct this question to Director Kapos. Do you foresee the need to deploy new automated tools to overhaul older systems as part of the effort to reduce the existing patent backlog? And assuming that you do, which we believe you do you have any idea how much that will cost?
Okay, well, thanks for the question. The answer is clearly yes. And in fact, we've already been doing a lot of work regarding new automated tools here at USPTO. And it started with our new Manual of Patent Examining Procedure and Trademark Manual of Examining Procedure that we have put out, including new editing infrastructure and new searching infrastructure to all of our examiners and to our editing team. We do plan to roll out new editing new searching capability to the IP community at large. Also, the thing that you should clearly notice already in the IP community is the ability to do much faster updates on the MPP and TMEP. We're releasing new versions on a much more timely basis now. You might have also noticed the wiki update tool that we provide to enable the IP community to engage with us in a discussion about the MPP and the TMEP. Both of those are available online, and they provide for commenting by the IP community in an actual discussion, rating, judging, and grading of answers and the like on various chapters of the MPP and TMEP that we're updating at any point in time. So those are a couple of examples. On the much broader scale, we're in the process of re-engineering both our basic patent examination infrastructure as well as our trademark infrastructure. The project on the patent side is called the patents, well, the trademark side version of the software is called Trademarks Next Generation, and we're working right now to prototype and put together a new approach to our trademarks-related examination software and trademark portfolio management software that will be, we think, very 21st century, very much responsive to the needs and requests of the trademark community. On the patent side, we're working on an entirely new re-engineered patent examination infrastructure called PE2E, Patents End-to-End. That system is already up and running, parts of it in our central re-examination unit. We're bringing it up first for our CRU examiners. And so CRU examiners are already actually using the PE2E system and getting value from it. And we're bringing up new components of it on a very regular basis. We're using the Agile software development methodology, which enables us to bring new function online essentially on about a monthly basis. So what you should be seeing as the IP community begins to benefit from this new software as we move really through 2012 and then especially into 2013, where we start rolling patents end-to-end out for our what's called core examiners, or our line patent application examiners. And as we move along and begin getting components of Trademarks Next Gen done, is you should see improvements in efficiency, improvements in searching ability by examiners. Importantly for the IP community, particularly on the patent side, we'll be able to dramatically reduce the number of documents and things we ask you to supply. So all of that, what I call McKesson compliance burden, things that you are sending into the office now, you will no longer need to send in. We will be able to have you stop doing that and save your time and money and just let us find all the documents. It'll include much better search capability for our examiners, automatic semantic searching based on the specification in the claims, alerting examiners up front to likely sources of prior art. So a whole range of capabilities that will dramatically improve the ability of our examiners to do their job. Now, the last part of the question, Peter, was on the issue of cost. Of course, these things are not cheap. They cost in the many millions of dollars, and you can look at our financial statements to get exact measures. But I will say, relative to both trademarks, NextGen, and patents end-to-end, we're spending actually far less money than we otherwise would by using the Agile development methodology and by having USPTO employees who are closely engaged, literally day by day, starting with our examiners themselves, and management employees, as well as IT employees from our CIO's office and from our line business units, trademarks and patents, who are intimately involved day by day, assigned, working to bring the software up. What that means is we're getting tools that are very well suited to the needs of our employees, not waiting for years and spending hundreds of millions of dollars only to find out we get a product that we can't use or that doesn't meet our objectives and requirements, but instead working day by day, ensuring that the people who have to use these tools, our examiners first and foremost, are getting exactly what they need to do their jobs.
Thank you, Dave. The next question relates to the PTAB proceeding. So James, I think this one is for you. What is or becomes public record if a PTAB proceeding is terminated because of a settlement between the parties? And even if there is a settlement between or among the parties, why doesn't the PTAB proceeding go all the way to a final decision in the public's interest to know more about the validity of a patent?
Well, first let me take the opportunity to say PTAB in the more expanded form, Patent Trial and Appeal Board, and respond to a question you haven't asked, which is when do we become that? We have not yet become the Patent Trial and Appeal Board. That will happen on the 16th of September this year. We're looking forward to that and to the new proceedings that become part of our charter when that becomes our name. The America Invents Act speaks less to what the public record will include for the proceedings than it does what it won't include. And specifically, both the statute and the proposed implementing rules indicate that the agreement that comes at the end of a proceeding may be removed from the public record on the request of one of the parties or both the parties if the various conditions are met. Absent the removal of that, the agreement itself would be part of the public record, and all the other documents which are part of the proceeding would remain in the public record as well. As to whether or not the Patent Trial and Appeal Board would proceed to make a decision in a case even when there is an agreement between the parties involved in it, that's certainly permitted by the statute and again also by the proposed implementing rules. Certainly there's the contemplation that there's a public interest which is above the needs of the parties themselves and at the direction of the director as delegated and certainly consistent with policies from the director of the agency. The board is certainly in a position to proceed with the matter to conclusion even if the parties have stepped aside from it.
Thanks, James. Let's see, we've got two questions now on our fee structure. So I think we'll give the first one to Terry Ray. Terry, the first question is, the current fee for an inter partes re-exam under the current regime is $8,800. But the lowest fee for what will be inter partes review is $27,200, which is an increase of just over 300%. And the fees get even larger with an increase in the number of claims under review. As a small business owner, this is going to be tough on our budget when we seek to challenge a patent that we believe should not have been granted to begin with and is likely to be the patent of our chief competitor. Shouldn't there be a small entity or micro entity discount available for this type of review?
Thank you so much, Peter. At the outset, I'd like to tell you that we are just as sensitive about cost as you are. And as our starting point, we looked to see what is our current cost for inter-parties reexamination. And in fiscal year 2010, that number was $31,688. And that's less than, or that's more than rather, the $27,200 fee that's currently our minimum for inter-parties review. So we decided to set it a little bit on the low side, assuming that most people would file an IPR or inter-parties review only identifying the minimum number of claims. So we tried to think what is the best way of balancing it, and we thought that most petitions indeed would ideally fit within this $27,200 range. As to the micro entity discount, Peter, that's a very good question. Section 10B of the America Invents Act does provide that fees set or adjusted under Section 10A, that's our fee setting authority, may be discounted for activities such as filing, searching, examining, issuing, appealing, and maintaining patent applications and patents. Now, unfortunately, an inter-parties review does not fit within the scope of those descriptors. But even more importantly, Peter, for microentity status, that can only be applied or used by a patent applicant or a patentee, and inter-parties review can only be, only a third party can petition for that proceeding. So that would be unavailable for those two reasons.
Okay. Thanks very much, Terry. The next question asks, why is the USPTO setting fees twice in the near future instead of setting all of its fees in one go? And we'll turn that over to Bernie.
Okay, Peter, thanks for the question. A couple of things I'd like to start out with. First of all, let me give you a simple answer to a very complex question. And the simple answer is that the American Invents Act requires us to have several procedures in place on September 16th. So for example, as Terry spoke about, we have to have inter-parties review available on September 16th. We have to have supplemental exam available likewise this September. And the statute provides that in order for these provisions or these new services to be available, the petitioner must pay the fee. So we have to have a fee in place by this September. The America Invents Act in Section 10 provides a methodology for the institution of new fees. And we've spoken about that a little bit already this afternoon, but I'll give you a more detailed discussion of it. Section 10 of the AIA requires the director to propose the new fees, which Dave has done. They're on our website, and also requires the Patent Public Advisory Committee, in the case of patent fees, to review those fees and to hold a public hearing. Last week, the PPAC held a public hearing here in Alexandria, and this Thursday, the PPAC is going to hold a hearing in Sunnyvale, California, and Dave Kapos will be there for that hearing. After the PPAC holds those two hearings, then the PPAC issues a written report. And we must look at the written report and take the report into account by the terms of the statute before we can implement the new fees or even publish the final rule in the Federal Register. And the bottom line is that this process is very elaborate. There's a lot of transparency. It's a great process. We're really excited to get everyone's input and looking forward to the PPAC's report, but we can't accomplish that within a year. So in order to have the new services available by September, we're using our existing authority, which was reiterated in the America Invents Act, and that's our authority under Section 41D2. And 41D2 allows us to set fees for new services equal to the cost of that service. So if you look at our notices of proposed rulemaking that we just published for post-grant review, inter-parties review, supplemental exam, you will see our fees set under 41D2, and there's a link to our website for you to see our methodology in calculating each of those fees. Also, I don't know if anyone's noticed, but we did publish an opinion on our website, and it's located at two different places. describing in more detail our fee setting authority. And you can find it on the AIA Web's microsite, and it's under fees, or you can also find it under the General Counsel's website, and I hope you'll take a look at that as well. So thanks for the question.
Great. Thanks very much, Bernie. The next question relates to our operating reserve, and I think this is a question for Director Kapos. Several people have questioned whether the USPTO should have an operating reserve, and some have even said that such a reserve makes the fees in that reserve more vulnerable to diversion. Why does the USPTO need an operating reserve?
Well, thanks, Peter. So let me answer the question this way. You know, in any business, whether it's a law firm or a company, you generally have a way to access capital, to access financial means when you need to, when something unexpected comes up. And so, you know, for-profit, public, and even private companies can go into the debt markets in various forms or take out lines of credit or whatever it is. They can issue stock. They have all kinds of vehicles available to them that are frankly not available in the government. They also have available to them something that, you know, every responsible business that I know of does, which is to keep some amount of essentially cash on hand so that the business can be operated from day to day and even potentially from month to month if the need arises. And so in the context of the government, where we don't have access to capital markets and some of these other tools that businesses normally use, you know, the USPTO is a $2.5 billion enterprise, if you will. We've got deliverables, services that we provide, patent and trademark examination and appeals and interferences right now, and re-examinations and post-grant oppositions and all these other things we've been talking about this afternoon. We've got a payroll that we've got to make every couple of weeks, and you know, all the many bills that you deal with when you're operating an agency that's got, you know, 10,000 plus going on, 11,000 employees. And in that context, responsible stewarding of the agency calls for having the ability to run the agency in the event of unpredicted happenings, whether they be dramatic downturns in fee income caused by financial and market events like what happened in the 2008 time period when the major recession occurred, or whether they involve other events that cause temporary partial discontinuities, such as continuing resolutions, which happen in the government, you know, essentially every year when we roll from one financial year to the next, and there's not a budget in place, and therefore Congress puts in place a continuing resolution that can put limits on spending. And so the idea of having an operating reserve is simply to have adequate financial resources in place at any point in time so that we can continue to responsibly run the agency even when contingencies like those and all the infinite other contingencies that can occur actually do occur. Now, one other thing I'll say about that is that this is not just a hypothetical. You don't have to look back very far in history to find where this agency came very close to having to shut itself down because it did not have any financial resources. It didn't have any reserve, and that was just back during the financial downturn. In fact, when I was coming on board in the summer of 2009, the agency was in serious trouble and was seriously considering furloughing its employees in the face of a backlog of, at the time, something like 770,000 unexamined applications. The agency nevertheless had no financial wherewithal to continue operating, or very little financial wherewithal. And so I came into the agency seeing firsthand and living firsthand through the instability that you face when you don't have any buffer, when you don't have any reserve whatsoever in order to deal with a financial situation like we had then. And that's simply why the reserve fund is needed. It will enable us to operate the USPTO in a business-like, professional fashion, no matter what happens in the external marketplace, and to do the job that the American public is asking us to do. And then just the last part of the question, does it make USPTO reserve fund subject to fee diversion? The answer to that, quite frankly, is I don't know. Nobody knows. But my view is we need to operate the agency in a business-like fashion. We need to be good stewards of its resources. We need to do the right thing. We've worked extraordinarily closely and well with Congress, and we will continue to do that, and we'll continue to make points and explain the purpose and need for the operating reserve, and move forward on that basis.
Great. Thank you, Dave. Peggy, I think this one is for you. People thought that the AIA would provide the statutory framework for the USPTO to implement an assignee filing regime. Why don't the proposed rules reflect assignee filing?
Okay, well, first I think it would be helpful to define what's an assignee filing regime or system. And that's one in which the inventors are not required to execute a document such as an oath or declaration concerning inventorship. But we can't ignore the express requirements in 35 U.S.C. 115 that the inventor execute an oath or declaration except in limited situations in which the assignee may execute a substitute statement in lieu of an oath or declaration. So the AIA did, in effect, provide for partial assignee filing where the inventor is deceased, legally incapacitated, or non-signing. In other words, in situations where the inventor cannot be located or refuses to sign.
Okay. Thank you very much. How will petitioners know whether to identify a particular entity as a real party in interest? And I think we'll give that one to Bernie.
Okay, thanks, Peter. This is one of those situations where when we were drafting the regulations, or the proposed regulations and guidelines and looking for definitions, it was one place where we thought a bright line definition would not be workable. And let me explain why. First of all, for those of you who aren't familiar with why the term real party in interest is important, it's important because the statute provides that the estoppel provisions for both post-grant review and inter-parties review applies to the real party in interest. And it's our proposed regulations, if you've looked at them already for post-grant and inter-parties review, provides that the petitioner is required to state who the real parties in interest are when they file their petition. And really the reason for that is pretty obvious, but it's so that the patentee, when the patentee files their preliminary response, is able to raise the issue that the proceeding never should have been filed because the estoppel provisions apply. And we looked at other areas of the law to try to analogize our definition to what is used in other contexts. And I can say that, in a prior life of mine, I was litigating cases at the Department of Justice, and there's many areas in the law where there are not bright line tests. For example, what is a fraudulent conveyance? For property interest, it's a factor analysis. Who's an alter ego of a taxpayer is a factor analysis. There's no ability to do a bright line test. And similarly here, who's a real party in interest? When we look at similar provisions in other laws, we found that courts could not come up with a bright line test, but really laid out a series of factors. If you look at the factors, the ability to control the proceeding is really a paramount factor. And I think that you'll find, although sometimes it's a little bit frustrating to deal with a factored analysis, it really allows James and his fellow judges to make the right decision based on the particular facts of the case, based on the factors that we've laid out. So I would encourage everyone to please look at our guidelines, the board's guidelines for their proceedings that we published in the Federal Register. We look forward to your comments. If we've missed any factors that you think are important, we would definitely love to get those from you. So thanks again for that question.
Hey, Bernie, just if I can add, that was a great answer. The one other thing that I would mention as a kind of a overarching policy view that I have on this issue of factor analyses and real party and interest and other, I've seen comments from folks in the IP community on other cases where the agency has declined to put some kind of a specific test in place or some kind of specific rules through this process. And I think that it is actually important for us to be judicious about getting into trying to set up, bright line individual or unique tests for the reasons that you give. But you don't have to look back very far to see the consequences that result from the agency trying to set up its own little artificial, self-contained world, and that's called inequitable conduct, right? We lived for years through a system where the courts were looking at inequitable conduct issues a little bit differently than the agency, and that culminated in recent case law developments that we finally were able to use as an opportunity to say, look, that's it. That's the end of it. We are going to conform the agency's view of the law to the court's view of the law. We're going to follow the courts in interpreting and working this law forward in a sensible way. And I think real party and interest is just another perfect example of where, in my view anyway, you kind of don't want the USPTO to set up its own little self-contained world. The courts are going to guide the law. You want the agency to stay aligned with the courts, and you want us to work forward, benefiting from all the law that's already out there on the topic of something like real party and interest, which is a term of art. It's used in lots of areas of the law. We can benefit from what the Supreme Court is doing in the Federal Circuit, and even the regional circuits on other areas of law where they decide on real party and interest questions in the district courts. And it feels to me like we should be careful in not trying to put in place our own sets of rules in those situations like this one where we don't really need to.
Great.
Okay, thank you. Okay, let's see, we've got two questions, one relating to incorrect examiner rejections and another relating to whether there'll be additional USPTO fee increases. So we'll start with the second one, and I'll turn that over again to Peggy. After the fee increases that are currently being contemplated by the PTO are implemented, will the agency have the resources it needs to reduce the backlog and to increase quality, or will additional increases or additional revenue be needed?
I think the straightforward answer to that, Peter, is yes, we will have the resources needed to reduce the backlog and to maintain and improve quality. And what I mean by that is that the proposed fees will enable us to reach our strategic plan goals of 10-month first action pendency in 2015 and 20-month total pendency in 2016.
Okay, well, that's good to hear. Thank you. Incorrect examiner rejections are a huge problem, according to this questioner. Given the extraordinary increase in the appeals fees, should the office consider refunding fees in those cases where the petitioner prevails? The situation with appeals is, in some cases, directly due to unreasonable examiner rejections in the eyes of this questioner. So who would like to take that question?
I can help with it to
Okay.
start, and then others may have comments also. It's a great question, and we actually are already working on that very issue as part of AIA, and you saw some placeholders that we put in the fees. We're looking to actually start finding a way to refund as much as we can within the limits of the law, and Bernie can explain why the statute actually limits the ability of the USPTO to, quote, grant refunds in some situations like this one. But what we are going to do to the maximum extent we can in cases where an appeal is filed and the examiner then, following the submission of the appeal brief, the examiner withdraws, takes the case back into prosecution, we're going to be, if I recall correctly, trying to provide a waiver of the subsequent issue fee that if the applicant's claims or the patent issues, in order to try and through that mechanism be able to make the applicant essentially whole. And then you'll notice the way we split the fees up differently under the appeals process in AIA is also intended to help in that regard and make it less expensive for the applicant in the situation where the examiner withdraws the appeal.
Okay, and I could just add, Dave, on the legal question, the statute is written, allows the PTO to provide for a refund in only two situations. One situation is where the fee is paid by mistake, and the other situation is where someone pays in excess of the amount due. And, you know, I'll say that, you know, Dave was thinking about, you know, actually implementing a refund in that very situation. I hope you don't mind me telling people. And I looked at it and basically said, Dave, we can't do it under the law because we have two decisions. We have a Comptroller General's decision. We also have a DC District Court decision where someone who appealed to the board and the examiner then reversed their rejection sued the agency or petitioned the agency for a refund of the appeal fee, basically saying, I've never gotten the benefit of the appeal. And the Comptroller General of the United States, who's expert in appropriations issues, and the DC District Court both consistently held that the appeal fee was not paid in excess of the amount due. They paid the right amount of the fee. And number two, they paid to appeal the examiner's rejection, and it was not paid by mistake. So there was no legal authority for anyone to give the patentee or the appellant a refund in those situations legally. So Dave did what we have authority to do, which is to delay the fees till later in the game so that the appellant actually can see the strength of their case, and the examiner also has an opportunity to reverse their rejection if they want to do that.
Right. Hey, Bernie, let me add one more thing, and maybe we can get Peggy and James involved in this part of the discussion, because it's a really great question, and we're extremely sensitive to making sure that when we take a case to appeal, it's really a case that should go to appeal, and where we all need to get our board judges involved in it. And so Peggy and James and their teams have been working together on identifying scenarios where we have cases that are already up on appeal that really didn't need to be there, or where we can get better at avoiding appeals, learning from appeals that have occurred, and doing a better job of examining at the core level, and then the board judges providing feedback and guidance to our patent examiner core to improve their capabilities, all with an eye toward ensuring, you know, back to the original question, that that we're not forcing appeals that are unnecessary, and that when an appeal goes up, it's really a question that needs to be decided, and that we're providing all the avenues in the world to pick up, all the avenues we reasonably can, to pick up real issues that in appeals that should have been decided by the core, and getting those back to the core.
Can I weigh in on this one? I'm glad you've said what you've said, because it allows me to provide the second part of the answer on the backlog that I wanted to provide but didn't previously because I was worried about time, which is to say this, that the backlog really has two components. It has a first big component, how many cases are being decided by the board and going out the door once those cases already have come in the door, which still leaves the second part, also big, how many cases are coming in the door. And as Director Kapos has said, we have worked together between the board and the examining core to look at how we deal with that second part. Really, chronologically, it's the first part, the coming in end, to see how we can address it. And we've looked at a few different things. Two of them I'll mention. One, opportunities exist, we believe, where there has not been an interview between the applicant and the examiner to see whether such an interview might advance the disposition of the case and create the lack of need for an appeal. So we're looking more at that. Statistics we've looked at show that in 70% of the older cases there has been no interview, so it's possibly a very ripe area for reducing inflow of cases to the board. Additionally, we have looked at instances in which an amendment after final has become part of the record, but is not in condition to influence how the appeal would progress, whether looking at that amendment after final might also advance the disposition of the case. So I think we can look during the course of the remaining course of this year for more advancement of those issues as we work together cooperatively.
And I can take a step back from what James just articulated. And when we're at the pre-appeal or pre-brief stage, what we've been doing in the core is looking at each area's processes and who's involved in these conferences and providing a consistent look and feel to them so that we get a very objective group of 3 conferees and have an outcome that we're certain that the case has issues in it that are ripe for appeal. So we're really shoring up that practice also.
Okay. Well, the next question relates to RCEs, everyone's favorite topic, and I'm going to turn that to Director Kapos. Dave, what is the USPTO's plan to deal with the increasing backlog of RC applications in light of all of the changes necessitated by the America Invents Act?
Okay, well, thanks, Peter. So lots going on relative to RCEs. For those who are trying to sort of keep up with the bidding, I'll just mention a few of the facts and statistics. One of them is that RCEs were created, I think, in the AIPA in about 1999 or so, and were intended by Congress to help provide an easy way to roll cases over where they need to be rolled over. I think it's fair to say they've had a number of consequences associated with them that probably weren't anticipated. Not to say that they're unhealthy consequences, but they're just the things that come up when a statute sort of winds up taking on a life of its own. And so that's what's happened. The rate of RCE filings grew rapidly throughout the 2000, 2001, 2002, et cetera, et cetera. Everybody remembers then that the TAFIS rules that were discussed, and one of the first things that I did when I got to PTO was to declare a halt to all of that, and that left us with a continuing escalation of RCEs. They were going, I think, when I arrived at the PTO at 23%, if I recall the statistic right. So we put in place a number of measures that were intended to broadly improve processes and efficiencies at the agency, the new count system, the new performance plans for examiners and then supervisors, et cetera. Those new systems weren't primarily directed toward RCE practice, but they did have components in them that were designed to change examiner incentives and office incentives to ensure that we were doing our best to engage with applicants early in the process, to use compact prosecution to conduct interviews so that applicants would not be required to go into RCE practice unless they wanted to. And the good news is we have clearly been effective at that, because that 23% growth rate in RCEs when I started at USPTO then went to 10% after 1 year, and then this last year actually went negative, meaning that we had fewer RCEs filed for the very first time since the RCE statute went into place. The very first time, this last financial year, we had fewer RCEs filed than in the previous year. I'm happy to say, so far this year, through almost half of the financial year, RCEs are going down even further. So with filing rates growing at large, RCE rates going down, they're actually decreasing quite clearly as a percentage of total filings. That clearly is the good news. Now, the thing that we remain concerned about, and I think the gravamen of the question, Peter, is that we also, as part of the changes in the way we handle RCEs, we put them on a slower part of the docket. And that means that they're sitting longer. And so there's an RCE backlog that is built up, and Peggy, you can remind me the exact numbers. The last I checked it was somewhere around 78,000, 80,000 cases.
82,000.
It's now, Peggy's saying it's now 82,000 cases. We're watching it closely. Are we concerned about the backlog of RCEs? Yes, we are concerned about it. And so we're in the midst and very close, we hope, to being ready to roll out 2 new measures that will help significantly with the two dominant modes of RCEs that many applicants tell me are the cause for them filing RCEs. One of them is late arriving prior art, like from a foreign search report or from a companion application or something, after a notice of allowance. And the other dominant mode is what you would call moderate or minor issues after a final rejection that could potentially be resolved if there was a little bit more bandwidth available for examiners and applicants to be able to talk after a final rejection. So we're working hard on those two major modes. We hope to have measures in place to help significantly with them very soon. We also are looking, and this is something Peggy can comment on a little bit more on ways to remix the RCE docket within the core in cases where we can move RCEs around between examiners and enable them to get processed a little more quickly that way. So Peggy, you
Right.
want to
Yeah,
add to that?
we're currently looking at the RCE workload with respect to the available firepower and doing an analysis to see when it would be appropriate to move this work for some examiners that have accumulated a larger number of RCEs. So we're in the process of doing that right now and should have, an approach developed very soon.
Good. The last thing I'll say, and then I think, are we running out of time here?
We're running out of time, but I think we can go a few minutes
Okay.
over. So
The last thing I'll say about RCEs is, there's been some public commentary about the proposed increase in RCE filing fees, and we do propose a significant increase. We propose to still heavily subsidize original patent application filing, but we propose to raise RCE filing fees to the cost to the agency of conducting the request for continuing examination work. So we are not proposing to exact any kind of penalty or to in any way punish applicants who are filing RCEs, but what we are proposing is to have the cost for filing an RCE equal to the actual cost to the agency of doing the work. And my basic premise there is, look, we're trying to improve the USPTO, as has already been mentioned. We're trying to dramatically cut the backlog, even more than we already have. We've made some pretty substantial progress there. We're trying to further cut pendency. We're trying to make all these other improvements that we've talked about. Obviously, the money's got to come from somewhere. It's not sitting in the agency currently, because all the money that was paid into the agency in past years has already been spent on examining past patent applications. So you got to get the money from somewhere, meaning if we're going to speed up, we're going to have to raise fees at some point in the process. We don't necessarily have to raise RCE fees as much as we're proposing, but if we're not going to raise RCE fees, we're going to have to go back and look at something else as part of this fee setting process, or we're all going to be back as an IP community and as a country revisiting the premises of what you want us to accomplish here at USPTO. So the view for raising RCE fees was, look, we're not trying to raise them higher than what it costs to do the work, but on the other hand, at some point you've got to find the resources in order to do the work that's in the agency, and we didn't want to send a continuing message to those applicants, increasing numbers of applicants who are using interviews and who are working well and getting through the process the first time through. We didn't want those applicants to have to continue subsidizing the applicants that are taking longer to get through the process. So it's a bit of a balancing act, and we'd be happy to hear more about it, talk more about it as part of our fee setting related discussions.
okay. We've got a couple more questions and we're running out of time, so we'll do a couple of lightning round questions if we can. And the first one will be directed to Terry. When will the fee setting process be complete, and when is the 15% surcharge going to sunset?
The Section 10 fee setting process will be complete, we anticipate, in March of 2013, and the 15% surcharge will sunset at that point.
It's a very concise answer.
May I add one year? And that is that, to those of you who are concerned, the small entity discount of 50% will continue to exist, and for those enterprises that qualify for the micro entity discount, you will indeed find your filing, search, and examination costs to have gone down. And that's the end of my advertisement. Peter?
Great, thank you. Peggy,
Yeah.
this one relates to supplemental exam. Why is a summary required for each quote-unquote document over 50 pages? And does this include does this include items of information as well as other documents submitted in the proceeding which exceed 50 pages?
Okay, well, let's define document first, and that includes any document other than the request that is submitted with the request. And it could be items such as NPL and other types of non-patent literature. The requirement for an explanation of how each item of information is relevant to each aspect of the patent identified for examination or supplemental examination requires the patent owner to separately describe for each aspect of the patent identified for examination, whether it's the claims or the specification, etc., how the item of information is relevant to that particular aspect. So if you contrast that to the summary that we're requesting, the summary of the relevant portions of any submitted document only require that the patent owner summarize the portions of the document that the patent owner believes to be relevant to the patent for which supplemental examination is requested. So the patent owner is not required to link these summaries to aspects of the patent that will be considered in the supplemental exam request. But the key piece of information here for takeaway is the summary is not required if the document is less than 50 pages. So in other words, if the patent owner redacts the document to less than 50 pages without deleting the relevant portion or portions of the document that provide context for the supplemental exam request, then that supplemental statement is not required.
Thank you, and I think this will be our last question in the interest of time. The USPTO's proposed fee structure strikes many people as too high. What would be the consequences of maintaining the fee structure at more or less current levels rather than raising them along the lines of the proposed fees that the PTO recently put out? And I think we'll start with Director Kapos and see if anyone has anything to add to that.
Well, I'll be very brief on this. The consequences would be we would still be able to make some progress against the backlog, at least for a few years, and some progress against pendency for a few years. We would not be able to meet our strategic plan commitments. In other words, we would not be able to get pendency down to its ideal level of 10 months to first action and 20 months to final action. And indeed, pendency, because of the growth in filing rate, pendency, while it would go down in 2012 and 2013, I think it would start going back up again, if I recall right. In 2014, it would actually, by the time we get out several years from there, the backlog would be bigger than it is today, and we'd sort of be back on unfortunately, a bad trajectory. So the net, Peter, is we can go down a more modest road if we need to, but it certainly will have consequences in terms of the service levels that the agency will be able to achieve.
Okay. Well, I think it's time to wrap up. I'd like to thank all of our panelists for an informative session, and I'd like to thank each of you for sending in your questions, both live today and over the course of the last few days. We look forward to doing this again in the next couple of months, so look for an announcement for the next webinar in May or June. And in the meantime, please look on our website, uspto.gov/America Invents Act, for more information on the America Invents Act. And with that, thank you very much for joining us.